Chair Representative Cannon, Vice Chair Senator Gossage, and Ranking Minority Member Representative Owsley, thank you, and the rest of the committee, thank you for the time to come and talk to you about the role of the courts, child protection courts, in the practice of child protection. I'm going to try and focus on areas where the legislature might have some role to play. I think that is a not easily drawn line. So I will, welcome at the end when we get to questions and such, we can talk a little bit about that. If I use acronyms or terminology, I was a practicing attorney for 13 years. I was your Lana Getz that the Justice mentioned for several years. I've been working with Casey now for several years. I know every acronym in child welfare, and they come off naturally, so please stop me and ask me what that is if I do that. I have the pleasure of working for Casey Family Programs, the largest foundation in the country working to improve, reduce the need for, and eventually eliminate the need for foster care in America. The team I'm on at Casey Family Programs, the Judicial and National Engagement Team, is a team of lawyers and judges, and we're specifically tasked with and work on really this question, this topic you've asked me to come here to talk about today. What's the role of the courts? A little bit about how do the courts manage that role. I'll say a quick thing when I talk about the courts. I think in two ways, and I'll try and be clear about that. There's the capital C court, which we usually think of as the judge, the individual who represents the power of the state that the court has. And we request of the court, we're requesting of a judge. But I also think of the small c court, which is all the people that make up the court, the judges, the lawyers, the staff, social workers in our case, and things like that. I'll try and differentiate when I'm talking about that, but I hope to have that understanding. And I think this is an especially important topic as much as we talk about child protection and kind of how kids get in there, oftentimes focusing on the practice of the agency and such, rightfully so. With very few exceptions, every child in care is there by a judge's signature, usually after a lawyer's advocacy. Some of the most difficult decisions that we have to make about children and families in our communities are made in child protection courts. It is oftentimes a place of potentially great shame and ongoing trauma for families. And it's where the families and community come to seek justice and support and to be heard. I think that may be the most easily connected reality of the courts, because I've heard that happening here today in your chamber as well. At Casey Family Programs, we talk a lot about the gold standard of lawyering of judicial practice. With both lawyers and judges, that refers to kind of what we all know of as excellent technical knowledge of the law, skills at understanding the law, briefing the law to courts, arguing cases to courts. It also, for lawyers, involves adaptive skills, like client engagement, empathy, and compassion. For judges, there needs to be an interest in guiding the court process. It is the judge's room, and the way things go in the court are the judge's role and responsibility. Judges having quality inquiry, and we'll talk a little bit about that. That's one spot where the legislature can have an effect, because the inquiry of the judge is usually going to be, we hope, seeking factual information relevant to the law that the judge is going to apply. And so what does the law call the judge to ask about? So demanding relevant facts about parenting, about the safety of the children that can be put on the record and made the basis of decisions. Making clear findings, conclusions, orders based on the application of facts of law. And minimizing children's time away from family, including the use of family separation only when it's necessary to protect the safety of children. So a quick overview of my time here. I want to briefly just set, in a very broad sense, the context of the courts in child protection practice, discuss focusing a little bit on the role of safety in child protection. And I'll kind of discuss a framework, an analytical framework of safety that applies both to child welfare practice. It is the foundation of your agency's practice model. I'm not going to talk about their practice model. I wouldn't be the one. But also as an analytical framework for courts. We've talked a lot today about safety of children. How do we think about safety? How do we talk about it? And then looking at some legal levers, a term that we're using on my team, but where are there ways to make changes in the system? And we'll look at a few of the Kansas child in need of care statutes. I didn't do any comprehensive look, but there are a couple spots I just want to point out and some things that we can talk about. High quality legal representation in judicial practice, and a little bit of structural and funding opportunities that enable that practice. Let's see if I could have the next slide. So just briefly, some Supreme Court jurisprudence that kind of set the stage for us. This started back 100 years ago. And the Supreme Court, about 100 years ago, found that families have a 14th Amendment liberty interest protected by the U.S. Constitution and most state constitutions, but they were looking at the federal Constitution, in the care, control, custody of children and their families. And I think, without going through all the cases and such, but I show you those to look at if you like. One line that comes through a number of those opinions that really found the right of families, the constitutionally protected liberty interest of families in their family, in the care of children, upbringing of children, education of children. This one line that talks about we're not going to abridge the Constitution to serve an interest that has no reasonable relation to some purpose within the competency of the state. And what the Supreme Court there was really talking about is something I think we hear about regularly through to today, is that the government's not a good parent. Right? That is not really what the government is set up for. The government is really set up for, and this gets into, specifically in Prince v. Massachusetts, the idea of parens patriae, which is the idea that the government does have a role in protecting vulnerable citizens that can't protect themselves, stepping into the role of the parent. And the courts really sit in that tension a little bit. Next slide, please. The other kind of federal sort of setting of the context of child protection is in a number of federal legislation. There's more federal legislation, of course, than I'm listing here, but just wanted to give a little bit of a lineage of that side of the conversation. Child protection really started, in the sense that we know it today, in the early 60s. Going back 30 years prior, during the Great Depression, there was the institution of cash assistance to families to support families in their homes. A lot of what happened during that time was that states chose to refuse to give cash assistance to some families based on finding that home or that family unfit for cash assistance, so it was just retained and not offered. And you can imagine there were a lot of good and bad ways that analysis was made and those decisions were made. That lasted in the 30s, 40s, and 50s. Then in 1960, a man named Fleming, who headed up the Housing and Employment Welfare, instituted a rule called the Fleming Rule. And the Fleming Rule said that the states cannot refuse to offer cash assistance to families in need. What the state can do is either give cash assistance to a family in need, or if the family is found unfit, then find an alternative placement for the child, and the money will follow that child to the alternative placement. That was in 1960. There were 166,000 kids in care in 1960. In 1961, there were 277,000 children in care. This was an unintended consequence of the Fleming Rule, I think. And so they instituted a couple boundaries, ways of analyzing that. That taking a child out of their home the home must be contrary to the welfare of the child, and that the state must make reasonable efforts to prevent the need to remove the child from the home. And there starts our modern child welfare system. The child welfare system ballooned, continued to balloon after that. And the federal government really relied on state courts to manage that analysis. Is it really in the contrary of the welfare of the child to be removed from this home? Has the state really made reasonable efforts to prevent that removal? And I think it's fair to say that the state courts, and this is not a comment on Kansas at all, this is a comment on the entire field, didn't stand up and play that role very well. So by the mid-70s, 70, 75, 77, there were 500,000 kids in care. So I just wanted to do that real quick, kind of establishing the basis of kind of what's the practice that we stand on today, where did it come from? And then kind of leading into the legislation that I've kind of picked out for us to think about, or just to identify. In 1974, we passed the Indian Child Welfare Act. This was a response to the fact that at the time, up to 30% of Native children in America had been removed from their homes for all kinds of reasons in all kinds of ways through all kinds of systems, and that was finally recognized at the federal level, and the Indian Child Welfare Act was passed. In 1980, the Adoption Assistance and Child Welfare Act was passed, and that really was the federal government saying, no really reasonable efforts, okay? And federal funding is tied to the provision of reasonable efforts and the courts finding reasonable efforts. Later, the Adoption and Safe Families Act in 1997 was a response to the story or the idea that children were languishing in care too long. So what that act did was a couple of things. It retained the contrary to the welfare and reasonable efforts findings required at the beginning. It set the child's safety as the paramount concern for all judicial decisions. It also created the idea of the second tier, as we talk about, of reasonable efforts, which is reasonable efforts to achieve a permanent plan, which might be reunification, but at some point, if that permanent plan is changed, then reasonable efforts to achieve whatever the other permanent option is for children. It also instituted some pretty strict timelines by which decisions needed to be made. The Fostering Connections Act was a big recognition by the federal government that we were inadequately recognizing and supporting the role of kin, role of relatives in placement, and offered some funding support, especially for older children. It also established the idea of extended foster care, so children don't come to their 18th birthday and are ushered out of their foster home onto their own, which was kind of the story that led to the Fostering Connections Act, and created some, so children can stay in foster care from 18 to 21. And then, of course, the Family First Preservation Services Act in 2018. This was really the federal government saying, we need to create a major, not shift, because it didn't move funding, but it added funding to prevention services. We need to make a major move to support the states in creating services that help keep children at home and not having to go into foster care. So in short, the role of the child protection system is to show restraint by not intruding on families unless necessary to protect child safety, and then to act to protect child safety when it is absolutely necessary. The role of the courts is to mind that tension. Next slide, please. So I'll start with just a few sentences about risk. Risk is not really my main forte, but risk is deriving from past experience, things that have been found to be associated with, in our case, child abuse and neglect. It is an examination of past experiences, gathering those kind of correlates with that, and using them in a predictive way to predict whether child abuse and neglect will occur in a family in the future. It is for the agency to decide how they're going to deploy limited resources in response to calls to CPS do we respond to that call? How quickly do we respond to that call? With what or whom do we respond to that call? It guides investigations. What are we looking at? What do we want to learn? And it kind of sets the stakes of what's going on in a family. What risk is not very good at is a couple things. One, understanding imminent harm in the moment, otherwise known as safety, and that's where I'll go. It is also a process that's kind of rife with false positives, which is part of the design, but it is not really the purview of courts. Courts should be about the idea of safety, and that's what I want to talk about for a few minutes here. So we've talked about safety a little bit this morning, or you have talked with folks speaking to you a little bit about safety. Safety, that word safety shows up in Kansas statutes as well as other states with more and less frequency. It is often not defined. Is this, safety? Well, we all know what safety is, right? But that can be difficult for people to define. It's one of those things we can ask for people what safety of a child is, and we'll get 4 different answers, which is difficult when we come to people asking a court to make a decision about safety, as well as other terms that aren't defined. And I'll get to that in a few minutes. But so there's this analytical kind of framework of safety. It was originally kind of applied to and written about with regard to the courts by the American Bar Association in correspondence with the National Resource Center for States, and understanding this framework of safety that is often the foundation of state child welfare practice models. I think that's the case here in Kansas included. It is in most states. But it also really lends itself to courts and a way to bridge common language and common analytical framework, conceptual framework across family experience, social work practice, and the laws and procedures and statutes that govern the court's decisions. So put simply, the safety framework is, do we see threats to child safety? Are the children that we're talking about vulnerable to those threats? And do parents have the capacity to protect vulnerable children from threats of safety? That's really the kind of simple analysis of the framework. From the slide here, you can show that the framework also kind of discusses ways of talking about each of those terms. So when we talk about threats to child safety, what is a threat to child safety? That's still a pretty undefined term. There are ways that we can look at in the statute where we can start putting definitions to it. But as an analytical framework, kind of thinking about that in a case, what we talk about is it something that we can observe, we can describe, we can say, I've seen this. Not, well, it just didn't feel right. It didn't look good to me, but it is this, it's this behavior. Something that's immediate or liable to happen soon. We're not talking about way off in the future. Does it have severe consequences? Are we talking about usual bumps and bruises and things like that kids might suffer? Or are we talking about legitimate consequences for a child that the state might feel the need to intervene in? And is it out of control? We talk about vulnerability in some ways. One, if we find threats in the home, we presume that children are vulnerable to them. But we have to ask the question on each child. If we find a home with a safety threat in it and we have a 14-year-old, an 8-year-old, and a 3-year-old, they may not all be vulnerable to the threat, and they may not all be similarly vulnerable to that threat. So the key piece about child vulnerability is we think about vulnerability specific to each child. And then protective capacity. And this is really the richest part of the analysis, the thing that probably takes a lot of the attention of players in the court. And the framework really gives us 3 kind of ways to categorize and think about that. Cognitive, do I understand that this is a threat to my child? Okay. Sometimes the cognitive ability of a parent to understand a threat is an issue in a case. Sometimes whether something's a threat is subject to reasonable disagreement. Behavioral, as a parent, do I do anything about my understanding that that's a threat? And then emotional. and this is really kind of getting into kind of two broad things. This is probably the richest part of the three, but the two that have resonated the most with me is, one, do I have the ability to empathize with my child's experience of the threat? Not what you might think of me about it, but what it would be like for my child to experience that threat. And two, do I have the kind of ability to maintain can I bring my adequate parenting self to every situation that calls for it? And what we know is things like substance abuse, mental illness, domestic violence, resource difficulties, poverty, can prevent perfectly adequate parents from being able to bring themselves to every moment that calls for their parenting. So that's a description of the analytical framework of safety. When we talk about how do we, is this child going to be safe in the home? Does this child need to be removed? When we're thinking about safety, that's an analytical framework that I offer you. It has been resonant for a lot of courts to hear about that. The framework kind of plays through cases. So if we find that a child is unsafe, kind of at the end of that analysis, we find threats, we find children that are vulnerable to those threats, and we find parents that are not capable of protecting those children, we think of that child then as unsafe as we find them. This is where reasonable efforts comes in. Okay? The framework talks about safety planning. Can we make a plan that keeps this child safe? And the key feature there is that that plan controls threats immediately. Okay? This is about, can a social worker, can the court, can we walk away from that family right now, and the plan that we put together would keep that child safe? This should be a frame for reasonable efforts to prevent the removal of the child. If we, at the end of that process, decide we've analyzed that a child is unsafe, we've thought about what a safety plan would be for this child, and we can't employ that today, that would be where a court should appropriately say this child needs to be removed. So we've talked about 4-step analysis before we've gotten to that part already. Every family that leaves a courthouse and their children are not in their custody should be able to answer this question. Do you know why your children are in care? And that should be the result of a fairly transparent, either on paper that everybody has read and understands, or discussion in the court about the framework that I just walked through. That would be the idea of conditions for return. Also then thinking about case planning. And I want to say that critical difference here is that safety planning is different than case planning. And this gets to jurisdiction versus custody. And this is a concept that I think it's fair to say most courts in the country lose sight of. Jurisdiction means the court has the authority to make decisions that the family, the department, the players in this case have to obey. Right? The court has authority to govern the parties in the case. Custody means while the court is exercising jurisdiction, do we need to remove this child from the custody of their parents and place this child somewhere else? And that different conversation has really been lost, I think it's fair to say, in child protection courts mostly around the country. Once a child comes into the jurisdiction of the court, kind of the assumption is that that means the child's going to come out of care. And one data point that would be interesting to know, and it's, I don't know if Kansas has it readily, it would be unusual if you did, so it's not a thing. How many children in the court's jurisdiction are in or out of parents' care, physical custody? I don't mean like they've been returned and they're about to be dismissed. That's an interesting number to know as well. But I mean, how often do the courts exercise their jurisdiction over a family without finding the need to remove a child from the custody of their parents, and at least minding the fact that those are two different conversations? And that, to me, is one that it's fair to say courts around the country have really lost sight of that difference. Once a family comes into jurisdiction, it's like, well, of course, custody probably comes right after that, and then what we're looking at is completion of a case plan before that child and parent are going to be back in their custody together, as opposed to maintaining the idea when the justice mentioned about dealing with the issues of why the child came into care, That's not a jurisdictional question. That's a custody question. Why the child came into care is because we found the child unsafe, and we couldn't, at the time, create a safety plan that would keep that child safe at home. So safety plans are about, can we, while the court exercises jurisdiction, while the agency is engaged, all that is going on, can we create a plan to keep a child safe that usually assumes that the threat to child safety is ongoing. So if the threat to child safety is apparent substance abuse and they're not adequately able to supervise a young child that needs supervision, the safety plan is going to assume that that parent is not just going to say, okay, I'll stop using and we'll fix that up. It's that plan, so that safety plan has to find alternative means of supervising that child while that child's in the home, if I can describe that. Case planning is about changing the circumstances, behaviors in and around the home such that the family can provide safety on its own and the court and the agency can go away. Completion of the case plan is a jurisdictional question. What this framework then allows us to do is think about when we dismiss a case. Because once we have a case, once we're involved with the family, once we've become attached to our role and responsibility of child safety and to this child, then letting go is a difficult thing. The framework gives us analysis. We've either eliminated threats in the home, we've enhanced protective capacity, or we've done some combination of both, to where when it boils down to it, the protective capacity in the home is adequate without our oversight, without our interventions to keep children safe on their own, including use of extended family and community services and things like that, but the family can engineer that on their own, and the court and the agency can go away. So I wanted to offer that analytical framework because it serves a little bit of a basis for just kind of then going through your statutes a little bit. I just grabbed a few, and just let's look at maybe how that plays. And also, I want to kind of think about what we've heard already today. Please. So here we're looking at, so I looked at the front end. So what's the front door look like? I'll look at the middle spot, which is adjudication and disposition. And then I don't have a slide on it, but I'll talk just a couple words on sort of the back end, permanency, the permanency hearing, that kind of idea. This is the very front door. This is the jurisdiction when I was talking about jurisdiction. This is your definition statute, 382202. It defines child in need of care with 14 different categories. I only listed 3 here. Most of the rest, if not all of them, are related to a little bit different sort of things, some education neglect, some runaway children, child trafficking, children who have committed acts that if they were adults were crimes, some of those things. I'm speaking kind of to that mainstream of abuse and neglect allegations and cases. And there's really the first 3 that speak to this. Throughout these next 3 slides, you'll see this yellow and green highlighting. What that means, yellow is highlighting words that are meaningful in the statute, but don't have any definition other than they're there and we all are familiar with the words, but that's about it. Green is looking at words that are defined in the statute. So we talk about the first one, adequate parental care, control, and subsistence, and the conditions not solely due to lack of financial means. That lack of financial means is a function of statutes that's been added, I think over the last 5 to 15 years is when that's become more common around the states, understanding that the interplay between poverty and child abuse and neglect is very close. And so understanding that we're not seeking to remove children solely because a home is not got the resources to do what they're perfectly able to do. But adequate parental care and subsistence, that's a standard that can have a child brought into care that can exercise the court's jurisdiction and is undefined. Similar with care or control necessary for the child's physical, mental, or emotional health. Obviously subject to a lot of people's definitions. The one statute that does have a lot of defined terms in it is that third one, of course. Physically, mentally, emotionally abused, that's separately, specifically defined, that phrase. Neglected, that's specifically defined. I put most of the words down there below. And I note that also the word harm in Kansas statutes is defined. And it's on the next statute, or on the next slide, I mean. But those are defined statutes. As a parent, when I go in with my attorney to court and want to say that this is, my child shouldn't be in care, the court doesn't need to exercise jurisdiction, those terms give me a little bit of an understanding of what we're talking about. More so, I would say, than adequate parental care does. Similarly, if I'm the department and I'm seeking to file a petition because I think this child does need to be under the court's jurisdiction, this gives me a little bit more of an understanding of what evidence do I need to gather, what do I need to present to the court, and ultimately, it gives the judge some framework on how I'm analyzing this. If I'm being told to decide whether this child has adequate parental care, here's where a lot of where that decision is going to come from. My gut, my experience, and everything that goes into all that. Next slide, please. So, the next front door that we really mind, I think, the most is how do children come into care? Right? The statute we just talked about is coming under the court's jurisdiction. That statute has not yet put any child in care. And there are 3 statutes that govern children coming into care. One, the first one, 38-2231, is the one that gives law enforcement the ability to pick up children on their own. This often happens in fairly emergency situations. I just arrested the parent, there's no other adult, and there's 2 kids in the home. These children are now going to be on their own. And all different kinds of just really in the emergent situation. And you'll notice that it's a reasonable beliefs, which most of the time in the law is similar to probable cause, right? So that's a somewhat familiar term. It is a very low standard, but it gives them something you have to have reason to believe. And then the child will be harmed. And that, again, is a defined term in the statute. So it gives the police officer a little bit of framing. Again, it's a situation where the officer is going to be in a fairly emergent situation having to address that, but it gives them a little bit of frame. The next way children might come into care is through the social worker asking the court for what's called an ex parte order. Ex parte means not everybody party to this conversation is here in this conversation. Right? So the parents are not part of this. The child is not part of this. This is solely the social worker asking the court to give me an order that's essentially like a warrant to pick up a child. Okay? But again, we see a little bit of defined terminology, harm. And here's the definition of harm: physical or psychological injury or damage. That you can hear in the safety framework, that severe consequences language. Physical or psychological injury or damage. It has to be not just it doesn't look good to you. This isn't a home I would want to live in or I would want my kids to live in. This is about creating physical or psychological injury to a child. It creates a standard for somebody to use to analyze. You also see here the contrary to the welfare of the child, and you see also a requirement that the department has made reasonable efforts to prevent the need of removal of the child. And so the court should be asking those questions and getting some factual presentation about whether reasonable efforts have been made. Next slide, please. This was a little bit of an interesting thing. So the third way children come into care, usually this is not coming into care, but this is the court affirming that the removal is okay. Most children, this would be another data point that you might be interested in. How many children come into care through one of these 3 doors? Law enforcement pickup, agency seeking a pickup order, or the petition is filed, the child remains in the parent's care, and they have a temporary custody order, and that decision is going to be made in court. Now, if the child, so it'd be interesting to know how often do kids come in. I would venture a guess, and this is not based on analyzing Kansas, but just in general. Most all kids come through those first 2 that I've already talked about, and most of those come through the second one, that pickup order process. That may or may not be different in Kansas. If the child remains in the parent's custody at this first hearing, then that pickup order standard with harm and the need to show reasonable efforts will be the standard that the court uses. That's the standard in Kansas for every initial order removing a child. That's partly governed by that federal legislation I talked about that says for the federal government to supplement the cost of foster care, the very first order that brings a child into care has to say the magic words, contrary to the welfare of the child. Within 60 days, there also has to be a finding of reasonable efforts. That's the federal legislation requirement. Almost all states, Kansas included, requires reasonable efforts to be found earlier, in this case, at the first order removing the child. But in most cases, the child's been removed through that pickup order. And so when we come here to the temporary custody hearing, this is the first hearing that the family is present. This is the first hearing where they might have counsel. This is that first hearing that a family is going to come before the community, before their judge, before the court, and be alleged to not being able to parent their children. This is that place that is incredibly difficult. It triggers past trauma, causes ongoing trauma to be in that space. It's very often for parents a place of shame, a place of frustration and anger. And so that's the kind of context that we're having this hearing in. But it is the first place that parents are actively in front of the decision maker when this decision about usually affirming the removal and the child will continue to be out of care. And I want to note two things about this statute. One, there are no defined terms in it. No separately defined in the code terms, right? Now we're back to health or welfare of the child may be endangered without further care, meaning custody, meaning in care. Which again, is a pretty loose statement. The second thing I'll note is that it doesn't require a showing of reasonable efforts. It's adopting, I assume, the intention was we're adopting the reasonable efforts finding from the pickup order, from the initial order bringing the child into care. Now, again, if the child's in the parent's custody in this hearing, then yes, reasonable efforts will be required. I'm going to venture a guess that that's rarely the case. Now, how the courts in Kansas deal with this, whether they maybe say, you know what, I'm going to ask about reasonable efforts anyway, I don't know. But the statutes don't require the court, when affirming the pickup order, with the parents, with counsel here to say, we have a different perspective on that, if they do, that reasonable efforts were provided. Thinking about reasonable efforts being, did we do what we could do to create a safety plan to keep this child safe in the home? Next slide, please. So the next spot I stopped was adjudication disposition. This is actually the disposition statute. Adjudication is really looking at those definitions, that very first code slide. The child's been alleged under one of those statutory provisions to be a child in need of care, and there's going to be a trial, clear and cogent and convincing evidence, clear and convincing evidence, I think is how the statutes here call it, about whether that's true. Which is actually a higher standard than most states. That's often a preponderant standard. Here it's clear and convincing. And that's going to be kind of a traditional trial that we're all, if the parties disagree and we're going to have a trial, is a fairly traditional trial that we're all going to look at. One thing I want to note back on that prior statute about that temporary custody hearing, some more data points I would be interested in. We heard from the justice the struggles, the way in which courts get representation to parents and children. I would want to also know, when does that representation happen? Do attorneys have an opportunity to meet with their client 5 minutes before the hearing? Do they meet with their client before the hearing at all, or are they appointed during the hearing? If any of you have had the opportunity to work with an attorney, the idea of working with them during the hearing that you want the attorney to represent you in is a really difficult way of working with an attorney. The idea that a parent is counseled in that hearing I would want to know a little bit more about what we mean by counsel. Do we mean there's a checkbox that there was an attorney sitting next to the parent? Or do we mean that there was an attorney appointed with some time to learn about the family, to meet with the family, say, hey, bring your relatives, bring your neighbors, or whomever could testify for you on whatever subject is relevant in the hearing? Or are they appointed and they meet 5 minutes before, which is not uncommon around the country? Or do they even meet during or after the hearing because the appointment happens as part of the hearing? So, getting to disposition. I'll note the statute starts off with talking about the court shall consider. And the statute does not call the court to consider reasonable efforts to reunify the family at disposition. When we talk about custody with the parent, we had some of the testimony and such earlier before the committee talked about, removing children that didn't need to be removed, getting children back to the care and custody of their parents. And so the question is, if I'm a parent and I come to the disposition hearing, so we had the temporary custody hearing probably 2 to 4 months ago. That would be one question, like how long do we really get there? I think the statute calls for within 60 days. Sometimes, that gets done and sometimes it doesn't. But so we're roughly 2 months after that temporary custody hearing. What's gone on since then? Have the parents changed their situation? Have reasonable efforts been made to reunify the family? Courts may be asking that, I don't know. But the statute does not call the court to ask that. If I'm a parent and I say, at disposition, like my kids have been out of my care for 2 months, I've been working on what the court identified at the first hearing as to why the kids are in care, and I want the court to hear that, and I want to be able to say to the court, I know you just found the child or children dependent, but I think, child in need of care, sorry. But I think I can have them in my custody as you guys with the services, they want to make that case. When they make that case to the court, what facts do they make to the court? How does the court analyze that request? And we see in subsection B, custody with a parent, it says the court may place the child with a parent. That's basically the legal analytical framework that the court is given to make that decision. The court may. So, back to a lot of gut decisions, a lot of my past experience, probably a lot of deference to one party or another that court has a preference for, things like that. It says that the court can place a child back into care with some services and provisions and stuff. Those are related to, like what that part of the statute is saying is build a safety plan around the family, and the court may place the child back in the care of the family with those services. So there is some relationship to the idea of safety. There's not really a framework for the court to make that decision. In the disposition statute, it really defers to the person appointed as custodian of the children to decide when reunification will happen. In that subsection D2, it says that if the custodian later decides to return the children to the parent, the custodian will notify the court, and the court may choose to have a hearing about that, or may just say, I trust you in your decision. So it really kind of defers that idea of reunification. And really, again, the standard is really the custodian has decided to do so. If the court analyzes it, you basically get to the standard. It's no longer contrary to the welfare or the best interest of the child. Again, two undefined terms in our statute. We spoke a little bit, or you heard testimony a little bit earlier about visitation. I liked the correction I heard about, parenting time, because that is what we're talking about in the field, if you will. This idea that it's not just visitation time, this curated time when the baby's been, or the child or whatever has been fed, clothed, napped, everything's been done, all the parenting has been done, and you all can just spend some time together. We have kind of sanitized that time a little bit. But thinking about parenting time, thinking about a parent who is able to read to their child as parenting and being able to demonstrate that parenting in parenting time. So I appreciate the correction. But in the code, it's still called visitation. And really, just the disposition statute in talking about visitation says that any party can make a motion for visitation and the court should decide that on the best interest of the child. So a couple things there. There's, again, no standard. Best interest of the child. I mean, that is a standard. It's undefined. So again, we're going to get to how does a judge make that decision. It also doesn't elevate the parent's request for visitation or the child's need for visitation over other parties or other people's interest in visitation. It doesn't prioritize that primary relationship. Oftentimes statutes will talk about visitation as a right of the child and the family. Oftentimes statutes will talk about the court shall maximize the amount of time that children, these are things other states have done. There's a good bit of research that talks about the connection between early and regular visitation or parenting time between parents and children being connected to more often reunifying families and earlier reunifying families, I think really for some kind of obvious reasons. We're maintaining and supporting the connection between parents and children. Next slide, please. Really quick, I'll just mention a couple things beyond disposition, that sort of back end of the code. One, there's nothing in the code that talks about there being review hearings on cases until the permanency hearing. So a naturally flowing case that doesn't have hearings beyond what the statute requires will have the temporary custody hearing vary within 3 days of the beginning of the case. It will have an adjudication and disposition roughly 2 months in, and then we'll have a permanency hearing around 11 or 12 months in, 10 to 12 months in probably. So we have a 6-8 month time period where there's not accountability, where there's not parties coming to court talking about what's going on, saying this isn't working well, can you help with this, that kind of thing. This is volume practice. You've heard a lot about this so far. In the states with the highest standards of low caseload salaries or whatever for attorneys and social workers, it's still volume practice, which for a lot of, especially lawyers and judges, means I'm hearing this case today and then I put it over here until it comes back on the docket. And it's difficult. If I'm a lawyer with 100, 150 or more cases, I have very little time. You heard the justice kind of really do a great job of just kind of walking through the day-to-day of an attorney that has 100 or more cases on their calendar. I don't have a lot of time to think about and to visit with and to strategize with and to support a family that's not on the docket for another 6 months. I'm not saying that's good or right. I'm saying that's real. And so the statute doesn't really require cases to come into court before the permanency hearing. My understanding from the summit is that some judges do. That's very discretionary. My understanding also from the summit is there are some judges with incredibly full dockets, excessively full dockets, because dockets are a function of the number of cases you have and the number of docket time you devote to them. And so we heard from a judge who had 40 to 80 cases on a half-day calendar. So if you can imagine being a family coming in, this judge is going to make decisions about your family, decisions like we heard this morning that are being made, being not made, and such, things that need to be worked on in a case, things that need to be helped, and you're hoping to come before the court and be heard and be known and be helped, and know that that judge has 39 other families to talk to in this half day on a light day. So I say that, one, to caution against the idea of just asking courts and judges and lawyers to do more. I think it would be, there's some research that would support that having more frequent court hearings, especially out of the therapeutic court field, that having more frequent court hearings improves the practice of law. You have earlier and faster reunifications, you have earlier permanency, kids spend less time in care. But just looking to one of your counties and saying we're going to pass a law, you're going to have another hearing on the docket. Now, this many cases, this many hearings for the caseload turns into probably a third to a double more. So now it's not 40 to 80, it's 80 to 160. So I just want to, there are structural issues that come along with the practice that we want to promote. Which moves me to the statute, or the slide that's in front of us. In 2018, the Children's Bureau changed the way the child protection, the child welfare manual was worded to allow states to start drawing down 4E money under the foster care, drawing down foster care money for the administrative costs of parent and child representation. I've listed up here agency representation as well. That preceded 2018. States have been able to draw down funding for the cost of legal representation for the agency, but not for parent and child representation. In 2018, they changed the manual to allow that, and states started submitting their bills for parent representation and being reimbursed according to a complicated formula I won't have us go through today, but some reimbursement from the federal government for the cost of parent and child representation. That has taken some stepwise moves expanding. After a little while, they also added the idea of multidisciplinary parent representation, which I'll talk about in just a minute. But the idea of usually parents' attorneys, sometimes children and youth attorneys as well, having with parent representation, having parent allies, meaning parents who have been through the system, parent mentors, and now are coming back to work with parents in the system to mentor them, having social workers and such in the legal practice representing parents, and that the cost of the social worker and the parent ally in that model is also part of what can be submitted to the federal government for reimbursement. They also talked about building out under the idea of candidate for foster care. And a candidate for foster care at the time was very state defined. Now under to cut to the chase, the Administration for Children and Families has formalized all that I'm talking about into a rule that was just passed last month, will take effect next month. So what it does is very much make more concrete these things I'm talking about. But they also, and in the new rule, it's defined by the federal government more so than by the states, but a candidate for foster care, meaning prior to the filing of a case. So the legal representation for a family prior to the filing of a case. And that representation, I've come to learn in the last couple of days, that Kansas has a foothold in that practice. There is some preventive legal advocacy going on in Kansas. But this statute, I think it also talks about reimbursing the lawyer costs for what are so-called ancillary legal needs. So oftentimes, eviction from a home, duties of a landlord to fix a home, things like this, access to benefits, family law and protection orders. There's lots of things that aren't mainstream in the child protection case, but that are very much affect the family's ability to provide safety. And to the extent that the lawyers are working on those things, or that they work with other lawyers who do that, that work can also be submitted for reimbursement. So this is the new rule that's been passed. There are approximately 33 or so states. My data on that is about a year old, so there may be a few more that are drawing down 4E funding for parent and child representation. So this is getting into a little bit the idea of building the structure that comes with maybe the mandates from the legislature that says, do more, do better. Just briefly then, because I know I want to leave some time for questions, there are various ways that national organizations and such have helped improve the practice of both courts and lawyers. The National Council of Juvenile and Family Court Judges is kind of the class of the league as far as judicial practice is concerned. They have an annual conference. They have at least annually a Child Abuse and Neglect Institute, you'll hear it called CANI, that states send judges to, and it's a really good kind of broad-based foundational education in child protection practice. They have a model courts program where courts apply to, and it's not about model like we're the model, it's about modeling practice They get mentor courts, they do site visits back and forth, and they learn to do things a little bit better. They also kind of have promoted the idea of reflective practice with judges. They have this courts catalyzing bench card, things like this that are helpful for courts. The ABA also runs a Reasonable Efforts Academy. They have done that in Kansas once with a number of your judges. We have worked with the ABA in providing that. It's a really excellent training focused on that reasonable efforts finding. How do we do it? Why do we do it? What are the groundings of it and such? Providing a little bit of sort of push for judges to really make that inquiry important. With attorneys, the ABA and the National Center for Counsel for Children both publish standards of practice. We heard a lot of that discussion earlier already about what are caseload standards, what are pay standards and such. What should you expect an attorney to do? Right? What knowledge should they have? How often should they meet with their clients? How should they file? Should they be expected to file motions? Should they be expected to drive the case? As an attorney who spent 13 years representing probably 80% parents and 20% children, it was always my and our office's perspective that we are going to, as much as possible, drive this case. We're going to be the horse in front of the cart. And we're going to be out in front. We're going to be pushing this case in a direction which was toward what they wanted. And that's kind of what standards of practice can talk about a little bit. I spoke about multidisciplinary children's parent representation. Multidisciplinary practice in children's rep is very new and starting to come up. But the idea of having social workers, parent mentors, or youth mentors, advocates, former foster youth as mentors, team advocacy. If any of you have been in medical practice and ever had the tremendous pleasure of enjoying team medicine, where your orthopedist and your general practitioner, somebody kind of get together and really let's talk, put all our brains together, that's kind of fundamentally what this practice is about. And it is incredible. There's been very good studies about it. The most wide-ranging and rigorous study came out of New York City, where they found children were removed less often, they were reunified more often and more quickly. Other permanence, this is a common thing you're going to hear me say with representation, but other permanency guardianships and adoptions happen sooner. They also costed that out, and in New York City, which is a big, you think, oh, it's New York City, they actually have about 10,000 kids in care, which is kind of surprising, I think, given their population, so it's not as inapplicable as it might seem. But over this time period of the study, they found if all the children all the parents had been represented by the multidisciplinary parent rep model, they would have saved $44 million. So one of the things that there are other studies around parent and child legal representation, including in preventive legal advocacy, where the idea is very short-term periods of representation for families, replacing, because you prevent a child from coming into care, 6, 12, 18, 36 months of representation. So just looking at parent representation, there can be, in addition to all the human benefits of that system, also significant cost benefits. I have done a lot of work with a clinic in Washington that does representation under a multidisciplinary model for parents who just gave birth to a substance-exposed newborn. And they just came out with their 2023 report. They served 259 families. 83% of those families remained out of care. 53% of those families were families of color, and that was not by intentional act. It's just the nature of the practice. And the average amount of legal time presented, offered to those families was 4 3/4 hours. So you get to see where you start to replace 4 3/4 advocacy for long-term parent advocacy. Just on the parent representation line, you can start also saving money. So I've gone longer than I had hoped, but I hope that's the end of the comments I have. I could talk for days if you like, but I assume you don't. Thank you for your...
We appreciate that. Thank you. Thanks for being here. Do we have questions? That's just a lot of information to digest, but thank you so much for personalizing it to our Kansas statutes and, you know, giving us something to think about and to look at. Do we have any questions from the committee? You do? Representative Howerton.
Madam Chair, this thought, I think, given the testimony from the whole day and then your presentation, and I'm trying to word this, do you feel that custody gives the advantage in a courtroom? Like where the parents are, if the goal is for the parents to be unified, the parents are supposed to be with the children. If the parents have custody versus the state has custody, does that give the appearance? Has there been any studies on that or thoughts on that?
I don't know of studies on that, just to say that right off. Are you focusing on the like that first hearing, the temporary custody hearing in particular, or just in general?
Just in general.
Certainly.
It seems like if the parents don't have the children with them, they would feel more defensive and.
One common observation in child welfare courts is that once children come out of the custody of the parents, the burden shifts from the state needing to continue to prove that this child continues to need to remain out of their custody to the parents having to prove that they've fixed everything and that they need. So there's this burden shifting. There's a lot of things around this. One, there's burden shifting. Who has to prove? The other thing is, what's the standard? We oftentimes talk about we remove for safety, but we reunify for well-being. Meaning, right, we're going to have this safety standard here, but I'm going to need to really like this place before I return. The standard raises. We also have, how does the court analyze where the family is from then to now? In most courts, because of lots of reasons, it's oftentimes on compliance with the case plan. How many classes did you go to? Did you finish that program? Things like this, as opposed to progress in parenting behavior. And part of what I think you might be able to hear there is one's a lot easier to measure than the other. And when you have lawyers and judges and social workers, as you've heard, who are super busy and don't have time to even go see people, how am I going to measure a parent's progress, behavioral progress, especially when their child is not in their care? So now we have to talk about proxy measures for that, meaning am I improving in my substance abuse treatment, and should that improve my parenting ability? And often it does, and sometimes it doesn't. But also just the difficulty in measuring progress in parenting, not only in just this service that we hope is at least calculated to be related to parenting.
Thank you for that. It just kind of seemed that when you said that the burden is on the state, I think that gets lost in a lot of these cases, it seems like to me, just from my limited exposure with this. It seems to be that there, and maybe this has changed a little bit, but better safe than sorry in removing children. And just what are your thoughts on that on the front end?
Representative, thank you very much. That's a point that I missed at the very beginning, kind of setting where our courts are in that tension between removal and not. And that is the idea that the court is really in a place of balancing harms. What has long been, so in just the time of my legal career, let alone before that, it was kind of understood early in my career that, you know, we don't have all the information we want. We're not really sure. So we're going to remove this child and place him in foster care because that's safe and easy and that does no harm. And we don't want to risk the potential harm of leaving a child at home. And I would hope that we have a lot of courts have kind of come to the natural understanding that removing children from parents is not an act that is without harm. A colleague with decades and decades of experience, mostly in the agency and analyzing child welfare systems and such, said to me one time, even a child who experiences relief from being removed from their home still grieves that removal and loss, still understands the world through the vision of their family, and is connected by family and culture in their bedroom and their friends and their toys and everything with that home. And so that is not an act that is without harm. And the question that the courts have to wrestle with every day, and hopefully we're getting to the place where universally we understand that, is it, do I do this harm because it's justified by a greater harm if I don't do it, right? That we're going to, which is the least of the harms that we're going to do? If that answers your question.
Thank you. It does. Thank you.
Further questions?
Madam Chair.
Senator Falscadeau.
Thank you, Madam Chair. Thank you for the presentation. I've been on this committee for a while, and you presented one of the best presentations ever, so thank you for that. In your earlier testimony, you said that every parent who leaves the courtroom, when they leave, they should know why their children were removed. So, with that point, do you know if when they leave, they also leave with a list of things they need to do to have that child placed back within their homes? So many times I hear that the parents leave the courtroom. The caseworker says, I'll call you in a couple of days to let you know what you need to do. And it concerns me, Madam Chair, that that translation or is lost. And then if there's a new caseworker assigned, it starts all over of what they need to do, and the bar just gets higher and higher. So, yeah, do you know if they leave with the understanding of what they need to do? And if not, what can you suggest? Thank you, Madam Chair.
Thank you, Senator. An excellent question. I wouldn't be able to talk about Kansas courts and whether families leave Kansas courts with an articulate understanding of what they need to do to have their, let me say this, what needs to happen for their children to come back into care. I'll emphasize the idea that safety planning is generally about external resources being brought to bear to create safety, not just the mom will do, the dad will do differently than they were doing, because if that's the case, then I would question why we're in court to begin with. But the idea of what needs to happen for my children to come home today, speaking as kind of a national perspective, the guess would be no, that they don't, for two reasons. One, dockets and time and difficulty of that and such like that, the analytical framework not being there. The other, it's really hard. There has to be the time to have the information brought, for the court to initiate an inquiry that can oftentimes be done by, tell me about how you're assessing safety in the home of one or both parents today. Let's have that conversation. What would it take to make them safe? What would it take A, B, C, and D? Can we do that? Well, we can't accept C. We can't do C. There's your condition for return. In fairness, it's current condition for return. As we talked about the facts on the ground today, if we come back in a month, that things may change. They may get better. We may learn other things. But just that current condition for return, that kind of idea of understanding this is what needs to happen for the children to come back into this home. The court being directive about who's going to do that. Generally, it shouldn't be, Mom, you're going to get this done, and Dad, you're going to get this done. Not to say that families can't participate in the creation of a safety plan, but that it's a little bit antithetical for them to be relied upon, because the idea is we've just assessed that the children are not safe in their home. And so understanding clearly what it is you need to do, who's going to go do it, and then when we come back together, I'm following up with those questions. Did we do that? Did it get done? Why are we not talking about the conditions being adopted? I would guess that's not happening. And that's not unique to Kansas. If it's not happening in Kansas, it's not unique to Kansas. It's part of what me and my team are running around the country hoping to promote.
And I
I
think
appreciate your response.
Thank you, Senator. Kind words.
so Representative Owsley and I were just at a meeting put on by Casey Family Programs in Washington, D.C., and one of the discussion groups that I was in, sometimes the lines get blurred between what needs to happen before the children can come back, can be reunified, and what needs to happen in order for visitation to occur, or family, that
Yep.
they think that all of that the plan needs to be going according to, as it's set up in order. And what we were discussing was the fact that what was it called? Not visitation.
Parenting time.
Parenting
Time, yeah.
That's just as much for the child as it is for the parent, so that needs to be occurring all along the way. And yes. I think that you've touched on that previously, but just want to make sure that we're talking about two different things there.
And it relates to assessing safety in the context of parenting time. Mm-hmm. Right? Assessing safety of the child in the custody of the parents is 24/7. Are they safe? If we've removed the children and now we're looking at parenting time, one, do we start with a presumption of unsupervised visits? And then again, that has to be overcome. And two, do we assess safety in the context of 2 to 4 hours rather than 24/7? It's a slight change in the context in which you're assessing safety to determine length, location, amount of supervision that might be needed.
We have a question from Representative Humphreys online.
Yeah, thank you so much, Madam Chair. I know we're running late. I'll try to make this quick, but I so appreciate Casey and what you brought to us in Kansas. I think it's been very helpful in the last few months and so on. I kind of had two things. One is I really appreciate, and you did it today a lot, where you talked about children in care. And what I heard last time when we had a presentation from you all was that sometimes we need to focus on the ones who are the most vulnerable. And that might be infants or toddlers or small children. And in Kansas, we have now, I feel like, gotten in the habit of calling everyone who's in the system a youth. And that kind of draws us to think of more like puberty, past puberty, and so on. So I appreciate you saying children, because I don't want to forget those young ones that are in care. So thank you about that. And then the second one is, now we're talking so much about safety. Your chart with threats and vulnerabilities was about safety. But would you agree, we're not just talking like physical safety. It's not just, are they physically okay? There's more intricacies in that, and it can be emotional safety also, because I don't want us to think a child is perfectly fine as long as their bodies are not harmed. If you would just expound on that just for a moment.
Yes, safety includes more than just physical safety. One thing to consider as the courts are examining emotional safety, psychological safety, some of those things, is those things are often much more subject to personal perceptions, or call for really high-level testimony and analysis and such like that. Physical safety has often been understood. It's a little bit easier for us on an everyday basis to see and understand and to measure. But the short answer to your question is yes, safety involves more than just the presence of physical safety.
Thank you. I want to keep that in mind too, because in the summit, we heard some things that I thought were a little I'm just going to say over the top in that area. So I really appreciate you saying that. Thank you. And thank you for being here. Thank you, Madam Chair.
I think some of that's all the more reason why we need to tighten up our definitions, maybe in our statutes. Representative Howerton.
Thank you, Madam Chair, for the second time. I was asked this question this week: why do social workers have so much power? And so it actually made me think about, I heard about the Veterans Court process where they have the team, and then you mentioned it today about having that team perspective to kind of balance things. So I appreciate that, and makes me think I'm not so wild in my ideas sometimes. But I know, you probably need to find that, yes. So is there, like, nationally speaking, is there a, like, like for lawyers, if they step out of line, they have to go before a judicial review and different things. Is there that kind of system for a social worker who does that? Do we have that in Kansas? Yep. Okay.
Yes, sir.
Okay.
I will defer to the very
Thank
confident
you.
answers you were
Yes.
just given, and you
Yes.
have witnesses who might answer that a little better than I.
Because I don't know anything about it, and I've never heard of it.
Yeah,
And so-
BSRB, a regulating board. And
Okay.
very, very active.
Okay. And how many states do have that, like that team perspective versus the one social worker making the decisions?
Well, I want to emphasize that that team perspective is in the legal representation office. So when I talk about the social worker there, the social worker works with the attorney and the parent ally to represent the parent. I'm not talking about the agency social worker. This is a social worker if I'm the attorney for a parent. This is a social worker that works with me to help you navigate this case from a social work perspective, and also a parent ally maybe from a mentorship and parent mentorship perspective, and I'm as the lawyer, and we use our skills, but we're part of the legal team. There's a separate social worker who is the agency social worker.
So do you think
There are
having...
also court models that promote more teamwork amongst the parties. So very often the therapeutic models, you mentioned the Veterans Court, there are baby courts, and drug treatment court models. Those are the two most popular child welfare model therapeutic courts that build structures that create more teamwork amongst the adversarial parties that are in a court.
I'm thinking that would help if there was more that team perspective in the agencies themselves with the turnover. Because when we see that a lot in Kansas, we hear that a lot. Oh, the caseworker had to change. And so, I worked in an adoption case, all the records were lost. So they literally had to start over from scratch. And if it was a team perspective, when there's a shift in the team, it wouldn't all be lost and they wouldn't have to start over. I'm just thinking out loud, but thank you for that clarification.
Thank you.
Are there further questions? Representative Owsley.
Thank you, Madam Chair. Not so much a question, but Rob, thank you for being here. I had the pleasure of attending the summit and now the pleasure today. And I've got all sorts of notes here, and I'm sure given time to digest it all, I would come up with all sorts of questions. And I just wanted to say, if this is your glimpse at Kansas, I look forward to a comprehensive look at it and the discussions we could have following that. So thank you.
Okay.
And as I recall last time, you weren't here last time Casey was here, but both times we've had really horrible thunderstorms in the middle of the night before you speak. So
It was wonderful.
I
It was
don't
cool
know
to
what-
see. Yeah, we don't have
don't know what
lightning and
that's.
thunder around.
I think the tornado sirens went off last time, didn't they?
Oh, did they? I
Simone?
didn't hear them.
Yeah. Okay, I think we're good with questions now. So thank you for being here again, and safe travels home.
Thank you.